Well, I thought I'd try to find something interesting and topical to talk to you about, and mandatory sentencing seems about as interesting as you can get if you set aside climate change and refugees. But mandatory sentencing is probably one of the most controversial topics. I thought I'd give a bit of a background on it, but I realise some of you are not interested in that, so instead I've got some absolutely beautiful watercolours to show you, so you can just track through. And they're by Noel Herrenschmidt. So I'll talk a little bit about what the research evidence says about mandatory sentences, and give you a potted history of how they came about. But then try to explore a kind of more sympathetic view almost as, why are they so powerful? Why do people believe in them? What is there about mandatory sentencing that entices policymakers? So let's start with the research evidence. And this is fairly clear, both American and Australian, and this largely summarises what the Victorian Sentencing Advisory Committee said. The key thing that mandatory sentences do when a judge has to give a specific sentence rather than picking from a range is the key thing that happens is that the prosecution shifts from the bench, from the judge, to the prosecutor. Because then the prosecutor has to decide whether to charge the person with one of the offences which is covered by the mandatory sentencing regime. And of course, that allows a lot more power to the prosecutor in terms of plea bargaining. So that's the main change. There's a massive shift from something that's public and accountable, namely sentencing in courts, to something that's private and largely unaccountable, prosecutorial discretion. Now, then the second thing that happens is that people are more likely to plead not guilty, because if they're facing a long sentence, they won't take a plea. They're much more likely to say, no, I'll fight it. And so the length of time spent in court cases blows out. And that seems to happen consistently across all of the jurisdictions that have had these laws. But then the third thing, which I think is particularly serious for the rule of law, is that it produces disrespect for the law. And this is, the strongest evidence is mostly Americans, because they go overboard with this. But, there's little bits and pieces of evidence here too. It's that judges look at something and they say, well, look, that's completely unfair. What am I going to do about it? And juries do the same. And what's likely to happen is they're much more likely to what's called nullify the law. That means they'll ignore the law or they'll get round it in some clever way. And so, some judges will just obey the law and send the person to jail for 20 years for stealing a pizza, as happened in California. But others will say, oh, no, actually, it wasn't a pizza, or he may not have stolen it, or the evidence isn't strong enough, so I'm going to find him not guilty. So there's more and more examples of what's called nullification. And so judges, because of their respect for fairness, are torn about whether they should obey a law that they consider inappropriate and disproportionate, or whether they should actually carry out what they think is a fair practice. So they're torn. Juries are even more torn. And indeed, one of the main reasons, a major reason for changes in law is because juries say this is a load of cobblers. So one example is infanticide. In the 19th century, a lot of jurisdictions had a death sentence for infanticide. Well, most juries thought that was inappropriate. So almost universally, and particularly the best evidence is in France, they acquitted virtually everybody charged with infanticide. Whereas if there'd been a much lesser penalty, they would have, they might have found the person guilty. So it produces disrespect for the law. Then there's a further problem that because people are more likely to fight it, there's likely to be fewer convictions. And so you end up, if you think this problem is really serious, you're getting a smaller and smaller proportion of the total population of the people who've actually committed offences actually get convicted. So is that what you want? And then the next issue is about disparity. the government often argues that it reduces disparity if everybody gets the same sentence for the same offence. But in fact, circumstances are invariably different between different offences, and it's not just between the same offence. There's all of the issues about aggravating and mitigating circumstances. So in general, what happens with a mandatory sentence is they pick one thing that they think is particularly important at the moment and privilege that over all of the others. Now, the examples in New South Wales are killing a policeman. They say, well, that's more serious than killing somebody else. So they have a longer sentence for that. Or a one-punch strike when you're drunk. Well, why is it different if you're drunk than if you're sober, if you kill somebody? So there's all of these anomalies that creep in once you start privileging one particular, it could be a type of person that's attacked, it could be a type of crime, it could be, in the case of a punch, the use of alcohol. The most common use of mandatory sentencing in the US, or the early sentence, were all to do with guns. So if you carried a gun when you're carrying out a felony, you got an extra 2 years. That was the New York rule. Well, what happened? Bearing in mind what the judges were trying to do to balance fairness and legality. First of all, they said, okay, well, yeah, this was a serious robbery. We'll give you 10 years for that, but actually we'll discount it by 2 years, and then we'll add on 2 years for carrying the firearm. So it ended up making no difference to the length of sentence. So it can produce disparities, or judges undermine it. So it's kind of, it really undermines the rule of law. This is the American research evidence. And then there's the issue that of those who are convicted, you see, most of these people have been diverted in one way or another, or the judges have found them not guilty, but those that are convicted are the ones who are treated most harshly. And they tend to be disadvantaged minority people who are already extremely vulnerable. So what's happening is there's a focusing of punishment on the most vulnerable members of society. And there's a bit of a debate about that. Some people say there's no effect on the crime rate. Some say it's tiny. I think the evidence from New South Wales is there'd be a negative effect in the sense it would increase the crime rate if it was widely applied. And here's the reason, is that we know sending people to prison doesn't actually make much difference to reoffending. It might increase it slightly, but it doesn't reduce it. That's with the evidence that boxers produced, and I've done independent studies that say the same thing. So I think basically there's really no evidence that sending people to prison makes a difference. But what you people do makes all the difference. Community corrections, when it's properly applied, can make a difference, and that's what the research evidence says. In fact, the latest reports I've just read say that smaller caseloads reduce reoffending far more greatly than almost any other intervention. And that's strong experimental evidence using randomised controlled trials. So I'll try to find that article for you, but it's very strong evidence. And so because we know that generally treatment in the community works far better than treatment in prison, if you take resources away from the community and put it in prisons, that actually is likely to increase the prison rate. So, but let's just sort of do a bit of a background history to mandatory sentences. They're a subset of a sort of wider group of fixed sentences. Now, mandatory sentences just fixes a minimum, but nevertheless, there's a wider issue about fixed sentences in which you do a particular offence, then there's a particular penalty associated with. And for most of human history, that's how it worked. So if you killed somebody's pig, then they would kill your pig. There was a fixed sentence for doing it. But in the 1880s, there was a kind of progressivist movement in the US that believed in rehabilitation. And they said, look, rather than giving a fixed penalty to somebody, before we know how well they can be rehabilitated, why don't we just give them an indeterminate sentence, like 1 to 20 years? And that was quite common in some US states. And leave it up to the correctional authorities to work out when the person's been rehabilitated. So, remember what I said before about transferring discretion to prosecutors? Well, in this case, it led to a massive transfer of discretion to correctional authorities, and based on a belief that people could be rehabilitated. And then there was a bit of cynical things as well, like if the prison was full, they cleared it out. But it gave a lot of discretion at the back end. And so that was sort of widely practiced, at least in the US. It wasn't so common anywhere else. But then in the 70s, there was a kind of belief that, well, things weren't really working, people weren't being rehabilitated, and it was unfair for some people to spend 20 years in jail and others 1 year in jail for the same thing. You know, regardless of their ability to be rehabilitated, it should be based on their culpability, what they did and what harm they produced. And so this so-called justice model came in, and it was sort of based on an idea that you'd get the minimum sentence consistent with the gravity of the crime. But once it became politicised, they kept ratcheting up the grid. So that's when grid sentencing became particularly pernicious. And it responded to a kind of punitive turn, and also various race riots and other things where people started to feel like the society was falling apart. So let's pick on the most vulnerable, lock them up, and then they won't cause a revolution in our suburb. And so it was largely people, African Americans in particular, were most affected by this. Whole communities were effectively destroyed by these kind of policies. But yet there was no provable benefit from it. So, as I mentioned, that mandatory sentencing tends to focus on particular things that are hot at the time, and the American ones tended to be serious violence and drugs and firearms, but then other ones, such as in Western Australia, the repeat offenders became a big thing. So you'd focus on people that had committed previous offences, and as you know, Singapore and Malaysia have both got draconian drug laws. Most of their nasty laws came from the English common law imposed by colonial authorities, so you know it's not a specifically Asian thing. And then burglary, home invasion in Western Australia was a major political topic, so they introduced laws for that. Northern Territory also introduced one set of mandatory sentences and abolished them a few years later, and then they've introduced other ones. So effectively there's a kind of bit of and Queensland's been doing the same thing. So there's a kind of bit of a national trend towards introducing these sentences. They seem to be fairly popular, at least with one side of politics. But the effect, one of the effects is that parole authorities are having their discretion severely curtailed. So that the US estimate was that before the mandatory sentencing came in, the parole boards basically used their discretion in about 75% of cases, whereas now it's down to about 20%. So really, the decision is made by the judge in the court, and the parole authorities don't have much control over that. Now, this is one study by Rand Corporation, and it just tries to say, well, is it a good investment to have mandatory sentences, particularly 3 strikes legislation? And they kind of believe in it. They think it's a moderately good idea. Unlike the evidence I produced before that said it doesn't make any difference, it's actually negative. They think it could work, that for every $1 million you could save 60 serious crimes, but it's far less effective than the alternatives. And in a kind of policy setting, it's important not just to say, does it work, does it not? It's compared to what? And if you put in the same amount of money in parental training, it would be about 3 times more effective. And if you put it into high school students to get them to complete, it would be whatever 258 divided by 60 is, at least 5 times. So the argument is that while even if you believe that it can work in terms of reducing crime, it doesn't work as well as other things. And in your context, it doesn't work nearly as well as support and treatment and supervision in the community with people who are properly trained. There's a whole series of things about community support that, that makes a difference. And the best group that looks at this is at Washington State. It's got an Institute of Public Policy, and they've compared all the different types of intervention that work, according to them, and the ones that work best are treatments by community corrections people. Although, I should put this in a bit of context. The broader view of criminology is the main thing that allow people to desist from crime is, first of all, getting a job, secondly, getting an education, thirdly, getting a stable house, and fourthly, being in a stable relationship. So they're the key things, but people are much more able to move into those situations if they're in the community. Okay, now let's sort of look a bit at the other side. If there's no evidence at all that mandatory sentences make any difference, in fact, the evidence is that it makes things worse, well, why would any rational person even think about it? And it's possible to say everybody's mad out there except me, and that may be true, but it's worth trying to stand back for a moment and say, well, is there some rationality to it? That image is of Cook County Jail. It's a particularly scary place. It's got a daily prison population of about 14,000 people. Now, so there are 4 arguments that can be made for why fixed sentences could be plausible, and I'll go through them one at a time. There's about natural penalties, that some penalties are appropriate, and then there's a kind of whole theory about the need for a scapegoat, and then there's the victims movement, and then there's an issue about the role of the public in controlling the judiciary or the judicial process. So I'll go through those one by one. Okay, now there's a kind of a long theory in crime prevention, if you like, that there ought to be some similarity, some equivalence between crimes and punishment. So if somebody steals money, you take their money. If they deprive somebody of liberty, you deprive them of their liberty. If you kill somebody, you kill them. So there's that kind of idea of equivalence. And it was probably, as well developed as anywhere by Hammurabi about 3,000, more than that, 4,000 years ago. And what they did there was each type of crime had a particular type of punishment. So let's take an example. You bought a new house, and after being there a couple of weeks, the house collapsed, killing the householder. Well, what's the logical answer to that, according to Hammurabi's code? You kill the builder. Okay, but now here's being proportionate. What if the householder's son is killed? Well, you kill the builder's son. Okay, so they had developed this whole principle of proportionality. Now, what if a surgeon made a mistake on the operating table? You chop the surgeon's hand off. So there was a kind of whole list of things, and this entered the Hebrew Bible as being an eye for an eye, tooth for a tooth, although that was entered much later. It didn't apply at the time that the thing was being written. But the theory behind it wasn't to be cruel or unusual in terms of punishment. It was to be proportionate. That if somebody lost their hand, no more than a hand would be lost by the offender. So it was designed to avoid lynch mobs, avoid vengeance, and to kind of have a more stable, quiet society. But there was another edge to this as well, and it can be seen very clearly in Sharia. In fact, this is the reason the British didn't like Sharia when they came to India. It had a high standard of proof. The British didn't like the high standard of proof, so when they came to it, they reduced the standard of proof. They also found that Sharia didn't have enough capital punishments. The British increased their level of capital punishment in India when they came. You know, now it's very important to understand the standard of proof. It was a way of avoiding people litigating, because what happened under Hammurabi's law and Jewish law and Islamic law was that if you made a claim against somebody and it turned out to be false, you couldn't back it up, then you suffered the punishment that they would have if they'd been found guilty. And you might think, well, that's pretty draconian, isn't it? Well, the purpose of that was really to avoid people taking unnecessary action, to keep a peaceful society. Now, Jeremy Bentham looked at some of these things, and he played around with this idea of proportionality in punishment. So he came up with and he didn't believe in capital punishment, but he had some quite interesting stories that have some resonance today. One of them was about drowning. If you tried to drown somebody, then and they were drowned, then you should be drowned yourself, perhaps. You know, so this was what he thought was proportionate. But if you tried to drown them and you didn't quite succeed, then he suggested a form of waterboarding, where they almost drowned you and then revived you again. So you know, it sounds a bit unusual, but it's designed to think about how to punish people, how to avoid unnecessary punishment. He also said for forgery, what would be a equivalent punishment? Well, you could stick a pen in their hand and pin them to the wall or something, because that had an equivalence. But there is a problem with natural penalties. There's all sorts of things where it doesn't quite fit. And one of the ones that Bentham mentioned was about if you engage in indecent acts, and he kind of implied flashing, then it's probably not a good idea to, as your punishment, go out and flash some more, because that wouldn't be seen as really punishment. And it's a little bit hard if you're caught speeding, you know, the punishment is go out and speed some more. So he said some things don't work. It's a kind of interesting analogy, and there can be some equivalence, but it can't work completely. Now, there's a sense in which natural penalties could be considered more appropriate for really serious offences where you don't want to take any account of the person's circumstances or their excuses. So let's say somebody committed genocide, they killed lots of people, and you know, they said, look, I had a bad childhood. It's almost like you want to say, look, it doesn't matter. The offence is so serious that no excuse can be entered into. And so the same argument is sometimes made at lower level than genocide, but to do with forest fires. If you throw away something and it was just, you were just smoking and it was an accident, and you say, look, it's no big deal, I didn't intend to hurt anybody. But if you killed several people because of your negligence, the argument is that that's still an extremely serious offence because of the amount of harm, and it doesn't matter what you thought at the time. There's another aspect that I think is important about these natural penalties, fixed penalties, and that's to do with the role of the monarchy. Now, we tend to think that all of the decisions about sentences are made in courts, and then later it could be reviewed by appeal courts. But for most of the history of the English common law, judges would issue the fixed penalty, and then the king would decide whether to forego the penalty. And that's happened, up to the early 20th century. Even the hangman had to get a royal dispensation after killing somebody. So there was a kind of whole tradition about, the king having this authority. And so it was quite common for the king or the governors on their behalf to exercise mercy. And it wasn't just because they were nice people, it was they realised there'd be rebellion on their hands if they killed too many. So there was a sense in which they managed the execution rate in order to create a bit of fear in the population, but on the other hand show that they were still, that they weren't unduly cruel. Now, the last time and you'll probably enjoy this story. And the last time the king tried to exercise the royal prerogative of mercy was in 1840. And George IV was the king, and he had a series of mistresses, and the mistress had a friend who was about to be executed. And so George formally went to the Lord Lieutenant, but it went to Peel, who was the Home Secretary, who then consulted with Wellington, and the king put in a formal submission asking for the royal prerogative of mercy to be exercised, and Wellington and Peel came back with the statement, what has the king got to do with the royal prerogative? This is exercised by Parliament. We're going to execute him. You have no say in the matter. So the person was executed. So that was the last time it was tried to be exercised. And then there's also this idea with natural penalties, and with the French Revolution in particular, where they had all these corrupt judges who were extremely arbitrary. They said, no, all the judge does is look up the book and apply the penalty that's written down. They don't decide. It's, the National Assembly has decided what the penalties is. The judge just applies the law. So that was sort of part of the thinking behind that. Now, the next issue is about scapegoats, and this is where it starts to get a bit scary, really. The idea is that most societies need scapegoats, that if they don't have somebody they can blame, they'll start disintegrating. And it's so much easier finding unpopular people that you can focus all your opprobrium on. And this argument has been best developed in relation to witchcraft, where it was completely fictitious, imagined crimes and sorcery, but some people were burnt as a result of this hunt for scapegoats. And the same occurs from time to time in relation to treason, where governments look for people that, the Stalinist purges were sort of one of the best examples. And there's this idea that, well, if there's something going wrong, somebody must be responsible for it. Now, I didn't really think much of this argument. It hadn't really occurred to me, but I was running some little mock trials with students at UWS, and we had this, what I thought was a completely bogus case about infanticide, where this woman was, charged with killing one of her children, and there was really no evidence for it. She went out of the room, and when she came back, it seemed like the older child may have shaken the younger child, but even then it wasn't really clear exactly what happened. So this woman was put on trial. It was a real case in Queensland, actually, and we deliberately, manipulated the case to make her look more guilty, because the evidence was so flimsy. It was Queensland, so she was found guilty, of course, and spent many years in jail. So the case was so flimsy, but we put it to our students, and the main thing they came back with is somebody's got to pay. And I thought, well, that's kind of interesting. Why do they have to pay? And anyway, why would you make this woman suffer if she hasn't done it? But it was sort of a deep-seated view that somebody's got to pay for this. And it doesn't need to be the offender. So there was often, in some earlier societies, if there were villagers fighting and you couldn't find out who the person who killed somebody else was, well, you would find a sacrificial victim. You'd pick one of the members of the village and arbitrarily kill them. It didn't matter if it was the right person. You can see this occurring right throughout history. Like during the First World War, there was a lot of cases of soldiers being shot. The French were the worst, actually, at this. They would, if a regiment failed to go over the top, they would pick usually 4 soldiers and they would shoot them. They were completely randomly selected, and they would shoot them. And that would be, those were the scapegoats. Somebody's got to pay for this. And the mothers after the war launched a big campaign about this, and it all became revealed. But there's something about the need for scapegoats, which it's argued is kind of deep in human nature. And that sentencing provides an opportunity for us to concentrate our angers and fears and anxieties on people who are unsympathetic in some way. Now, each generation has a different group of people who are unsympathetic. Today it would probably be pedophiles, And people say, well, of course, nobody should have any sympathy for them. But in an earlier period, it could have been those who were disloyal to the crown or defaced coinage or, poached on royal estates, or, there's always particular things that you could find people, or the Irish in Liverpool in the 1860s and 70s. There was a really, I did some of my research on this, there was, real fear of the Irish, and so they would stigmatise them and attack them, and they weren't any different from anybody else, but it's just that there was this need for venting, and it was focused on this particular scapegoated group. Now, once you start talking about scapegoating, you think, well, there's something really strange going on here. Is this a modern society? Do we need scapegoats anymore? And I could refer you to certain Sydney tabloids, and you can see that tabloids are alive and well and a very important part of our society. But what should we do about them? And sometimes it's judges that become scapegoats, or it could be police. So there's something about, I think, the need for scapegoats that looks for rotten apples rather than rotten orchards. That it's too hard to say, look, this whole system sucks. This is just a convict colony, the whole thing's rotten. That implies that we're all a little bit corrupt. And we know we're not. Other people are, but we're not. So we've got to sort of think about, well, how can we confine that stigma to particular groups? Well, let's find some groups that nobody else likes either. And if we concentrate our fear and hatred on them, then we can all lead happier, safer lives, because we know those dangerous people are locked up or punished. And we can create social harmony out of targeting particular vulnerable individuals. So that's the kind of the argument that the people that write about scapegoats say, that it's actually necessary and important, and everybody does it. But the thing about mandatory sentences is that it picks particularly suitable scapegoats. People are even more vulnerable because they weren't, the prosecutor wouldn't move them out, and the judges and juries wouldn't nullify. So they're the people that came through at the end, and they're probably the ones who are most unsympathetic, and therefore we can feel even more righteous in heaping long sentences on them. So anyway, that's one of the theories about why it's plausible to have mandatory sentences. Plausible in this somewhat bizarre way. Okay, now the other thing that's going on, as I'm sure you know, is there's been much greater emphasis on victims. Before the 1880s, there weren't really public prosecutors. They were there in the US a little bit earlier, but it was effectively private citizens that prosecuted cases. So the victim was the prosecutor, and so the victim had a major role in trials. But then once public prosecutors came in, they basically pushed victims aside and said, look, it's a state matter now, leave it in my hands, I'll prosecute the case. So victims somehow felt left out. Now, that's how it tended to go in common law systems. In civil law systems, there's a much stronger role for victims to be a kind of civil party. So if you go to a French trial, you'll see that there's the prosecutor on one side and the defence lawyer on the other, but there's also a space for what they call the partie civile, the civil parties, and they're usually represented, and they're able to ask questions and then cross-examination and take part, and they have a special seat in the courtroom. So I'll give you a couple of examples of things that they do, some of which you might agree with and others you don't. One, there was this guy who was quite clearly a professional hitman, and he had been in hiding for a couple of years in Algeria, and they arrested him and brought him back. And the lawyer for the victims was asked, have you got any questions? This is right at the beginning of the trial. And the lawyer said, yes, just one question. How many other people have you assassinated? And the judge initially, thinking a little bit like an Anglo-Saxon, said, I don't know if that's really admissible. And then it turned out this guy, being a professional hitman, he'd been convicted at least half a dozen times, and he'd escaped from prison and he was on the run from that. So it was ruled to be admissible. But, prosecutor probably wouldn't have said that, but the victim's representative felt that they could. So, if you're a victim in that sort of situation, you would feel like your rights are being looked after. Another case that I think is even more interesting, it was a murder trial in the outskirts of Paris, and the guy was charged with shooting. He was sleeping rough in a warehouse and with a gun beside him. Now, the reason he was sleeping rough was because his wife had kicked him out because she didn't want a gun in the house. So he was sleeping rough in a warehouse with his gun. And it seemed like a few people came in to steal scrap metal, which is sort of quite normal in warehouses. And he pulled out his gun and he fired into the dark and he killed somebody. Now, it wasn't really clear how many people there were. If it was a whole gang, then maybe he should have been frightened, and if it was one, maybe he should have hidden. And so they were kind of a bit confused about this. And then, in this case, the victims, there was the mother and the child of the man who was killed. They were sitting there, and this little boy put up his hand and said, I've got a question, and he was about 10. And the judge said, yes, ask your question. And so he asked the question to the accused, how many cigarette butts were there? Now, if you're on UWS campus where they don't allow smoking at all, that would make no sense at all. But if you're in France where everybody smokes and they all smoke different brands, then that's actually the key question. So this was from a 10-year-old kid, the son of the victim, and immediately the judge heard that. She knew that was the right question, and she spent the next half hour following it up. So, from their point of view, and then just later in the trial, when the accused made a derogatory comment about the person he killed, the judge said, no, that the victim and the family is here. I'll ask you to apologise for that outburst. So he turned to the victims and said, please excuse me. So you can see that even though in our system, victims are largely excluded, that's not always the case. And I'm not saying we should, just adopt things from other traditions, but it's worth thinking about that the victims movement has progressed quite differently in different places. But however it's gone, it's moved towards this idea that there are two competing rights involved. There are rights of the accused and the rights of the victim. And so the people in favour of mandatory sentencing always say, oh, well, the balance has gone in the wrong direction. So they use this metaphor of balance, whereas at least in a common law tradition, it's not a balance. The rights of the accused are fundamental and you don't undermine them. And it's not a matter of taking away some rights of the accused in order to make victims feel happy. But nevertheless, that's the metaphor of balance that underlies a lot of the demand for mandatory sentences. And one of the corollaries of balance is that, it's okay if you give somebody an extra few years in jail if the victims and their families feel better about it. So there's something about, suffering that becomes a good. If you give enough of it, then that'll atone for the harm that's done and people will feel good about it. Macaulay, in his History of England, once made a comment that the Puritans stopped bear baiting, not because it gave pain to the bears, but because it gave pleasure to the spectators. And that's actually quite an important insight about, is it ever appropriate to consider the satisfaction or the pleasure of the spectators or of the victims? Is that actually an ingredient that should be included? And clearly with mandatory sentencing it is, because at the end of a sentence, if somebody gets 4 years for a one punch death, and then they interview the victims and they say that's not enough. I feel bad. I feel like I can't reach closure because this punishment wasn't severe enough. This person won't suffer enough. So there becomes a kind of calculus of suffering that enters this whole equation. And then there's the issue about the public and what rights they have in the process. And so there's often an argument that things are becoming far too professional. If we're real democrats, then surely the public should be able to, take part in things. We should be able to decide what happens. Surely the judges should be doing what the Parliament tells them to do. What right are they to have to impose their own moral standards? So there's a bit of a debate about, controlling the judges. And there's also a demand that there should be something a bit more entertaining for the troops, that, instead of having these technical sentences that nobody understands, where people don't appear to suffer, if we can have something that's a little bit more exemplary, then that will create, we'll be more satisfied. I just had an example here. Maybe I'll think of it in a minute about the discretion. Oh yes, I know what it was. If you in France, what they do is, in quite a few European countries now, juries are involved in sentencing. And so whatever's the really unpopular thing at the time, they can get exemplary sentences. Whereas, as I said before, with things like infanticide, that's when they would nullify, they would find the person not guilty. Well, there was a string of cases involving paedophilia. And prosecutors, their role in France is to ensure that there's kind of proportionality. So they, if you read the French Penal Code, it's kind of like the most serious crimes are to do with genocide and crimes against humanity, and that's listed number one because it's the most serious. And then it goes down to murder and homicide and all the different types of killing, and then it goes to rape, and so it's kind of like very hierarchical. And so prosecutors, they like to keep this proportionality going. Well, with some of these paedophile cases, the jury were giving people longer sentences than they would for murder, and this of course screwed up the sentencing database completely. And so there is a kind of issue, well, how democratic do you really want to be? The French Revolution, democracy largely meant that they brought in a whole lot of tame people who then sat on a jury and put people on the cart to be guillotined. It was a particularly strange form of democracy. The Americans, have much more emphasis on separation of power and balance between different authorities, and to avoid, and de Tocqueville, who's one of the main exponents of juries, he didn't actually like democracy because he didn't think that mob rule was particularly something to be aspired to. What he wanted was sensible, rational people making decisions, but with democratic input. And so his view about juries was that the ordinary common people would learn a lot from working with their betters on the jury. That's not the version you get when people talk about de Tocqueville today. They say he's all into this wonderful experience of school for democracy. Whereas in the 19th century, democracy was a pretty dodgy word. There was a lot of problems with the idea. You don't want ordinary working class people participating too strongly in politics. You don't know what they might get up to. So there is a kind of issue about how much democracy and what it really means, and then there's the issue about election and whether decisions should be made by unelected officials like judges, or people who are drawn from the community like juries, so they in a sense have more authority than judges, or by people who are elected in parliaments and councils. So what should be the balance between those things, and should all decisions be made by people who are elected? So certainly part of the push for mandatory sentencing has really been saying don't allow unelected people to make these decisions. It should be the elected official. Well, the problem with that is in the US, there's so many of the judges are elected. and they still get nobbled by their legislatures. So, in fact, that's a bit of a spurious argument about election. And in fact, if you look fairly carefully at how judges are appointed, they have to be acceptable to the powers that be. They're really appointed by the government. So there is a sense in which people who are considered too extreme, or one way or the other, are not appointed as judges. Whereas if they were just given short terms, then they'd be more likely to be beholden to the government of the day. They'd have to look over their shoulder to make decisions that would allow them to be re-elected or reappointed. So American judges are very conscious of looking over their shoulder to the electorate. So, there's a real issue about elected officials. And then finally, about the judicial process, the importance of crime and fear in public policy. That, we often think about public policy as just a bunch of policy wanks sitting around looking at evidence and deciding, what's the optimum outcome given the level of resources. And in a sense, as an academic, that's what I say, but I don't necessarily think they'll believe me if I say it. So it's important for us to continue arguing in favour of evidence-based research and carefully monitoring the effect of things, but we shouldn't necessarily assume that anyone is really listening to us. We can sometimes, there could be windows of opportunity with governments that are particularly progressive, and from my experience that happens more in Victoria than New South Wales, but nevertheless it's something that comes and ebbs and flows. And we shouldn't abandon evidence-based research as a kind of mantra, but nevertheless we also need to take account of all these fears and anxieties and hatreds that are there that also shape public policy. So what I'm trying to say is, well, do we just appear to be rational human beings and ignore all that stuff and say, look, that's beneath us, we shouldn't get into that game at all, that's really to do with, that's just the media, that's just the gutter press, that's the shock jocks, those people are just not serious thinkers, they're just inflammatory maniacs, or do we say, look, there's something going on there, there's something about these anxieties and fears that has got an element of rationality, and what is it? Can we address it in other ways, not by picking on scapegoats and locking them up for long periods, but is there some other ways in which we can address those anxieties? And in the case of probation officers, one of the most important anxiety-producing things is when somebody who's on parole or probation, commits some terrible crime, then you get this massive outcry, as you know better than I, and you get a kind of moral panic in which everything clamps down, and they partly blame all of the workers who are involved, and then they blame the system, and then they punish everybody else. So what is it about this system that we can address with rational arguments, bearing in mind that a lot of the heat that comes out of it comes from these fears and anxieties? And the reason I came along was to ask you these questions. I've got no idea what the answer is, but I thought it's a really important question, and one that we do need to start addressing. But my angle, I suppose, as a criminologist, is I think that anything that encourages disrespect for the law is a little bit problematic. That one of the things that does hold our society together is some kind of respect for proportionality and fairness and so on. And once judges and prosecutors and police and everybody have to start going around the law and to achieve justice, it will encourage corruption. There's too much corruption already, but once you build an incentive to corruption into the law, then it actually means it will become more widespread. So I think that's an important issue. And then the point I'd like to finish with is about this tension between democracy and the rule of law. And sometimes judges, correctional officers, police have to do things that are deeply unpopular, but they're lawful. And it's particularly the case with vulnerable people who other people would say, look, forget about them, they don't deserve protection, we're not going to care for them. in terms of the rule of law, everybody is equal under the law, and everybody's rights should be protected. So while it's great to have democracy, in fact, I remember when I was at graduate school in an American university, and it was sociology, so we were a little bit Bolshevik, and we decided that we would make all the key decisions and marginalise the senior management, and the provost of the university, very important person, came in and he said, look, I got my degree at Harvard and I know about governance of university. And he said, democracy is a fine thing, but it has no place in a university. So I think that there is a battle about democracy and the rule of law, and it's a serious debate that we need to engage with. So thank you very much.